On behalf of Todd Ducharme and I, we'd like to welcome you here this early Saturday morning on a very busy time of the year. It's great to see so many of you here. Todd and I are quite excited about this program. Dynamic Defenses is definitely distinctive in terms of a program. How's that for alliteration, first thing Saturday morning? This program is going to provide you with a review of the law and some practical tips which should be of assistance to you in carrying out your practice in an area which we find has fallen into the shadow of many other continuing legal education programs which seem to focus these days on offenses, evidentiary issues, and charter challenges. We seem to have lost sight of what's going on with defenses. And the law in relation to defenses is quite a fruitful area for defense counsel to pursue, as I'm sure you'll find out today. Our program today is designed to present you with some ideas in presenting these defenses and also point out some pitfalls that may arise. And at this time, it's my great honor and pleasure to introduce to you our first panel. Seated at my far right is Mr. Justice Archie Campbell, a jurist who is well respected for his intellect and enthusiasm in dealing with legal issues which arise in the courts before him in homicide and other trials. Mr. Justice Campbell has contributed greatly in many capacities to the development of the law over the years. And we are honored to have him with us today, particularly in light of the intense murder trial that he's now presiding over in Whitby involving a police officer. To my left is a defense counsel who I'm sure needs no introduction. Edward Greenspan's name was the name of the defense counsel who first came to mind when Todd and I designed a panel called Not My Guy, Running a Cutthroat Defense and Pointing to an Alternate Suspect, anything or anyone but Eddie's client. Eddie is an extremely experienced and effective defense counsel who is well known for running this type of defense over his 30 years at the bar, and I'm sure that he will have something helpful to say about this area. To my immediate right is Hilary McCormack. Hilary is now the Crown Attorney in Ottawa after having worked as an Assistant Crown Attorney for some 17 years, during which time she has prosecuted many homicide and other assault-type trials, and she has also been the co-director of the Crown Attorney Special Program in Homicide. I would also commend to you the paper which Hilary has written at tab 1 of the materials. It's an excellent review of the law in this area. At this time, I would turn the panel over to you. Thank you.
Hear me okay? Thanks for the introduction to all of us. You have before you, as has been mentioned under tab 2, two papers, one by Hilary McCormack and one by Jeff Schrader on tactical considerations in other suspect cases. I think you'll find these papers very valuable. There's been relatively little written recently on this topic. In a recent murder trial, counsel were all looking for material on the third-party suspect issue. And apart from one helpful paper by Alex Rubinski written a number of years ago at one of the summer Crown schools, there was very little out there that was written that can help the judge and counsel sort through all of the cases and issues that arise. So I think you'll find these papers very timely. They'll be very helpful to Crown and Defense Counsel and to judges. What we're going to do is that Hilary's going to go over her paper for about 10 minutes or so. It'll be followed by about 5 minutes from Eddie and 5 minutes by me, and I'll speak very briefly to Jeff Schrader's paper. Then we're going to go to 3 fact situations, 3 scenarios involving some, first one involves some bad Russian mafioso, allegedly bad Russian mafioso charged with murder. Second one is one of those tragic dead baby and 2-parent cases. And the third one is a lookalike rapist. And we'll use those scenarios to try to develop the issues that are in the papers from a legal and practical point of view, tactics, strategy. And after those, we'll have, if there's any time left, we'll have a very brief wrap-up comment by the panelists. Hilary?
Thank you, Justice Campbell. 10 minutes isn't very long to get through the papers, so what I'm going to do is just set out some of the very general principles and any of the cases that I refer to, I will not include the citations. They are all in the paper. For the purposes of our discussion later on, we are leaving tactical considerations for that discussion, so I won't be discussing that in terms of the general principles. The topic is Not My Guy, and is also commonly referred to as other suspect defenses. And the general principle is that an accused can point to a third party or other suspect in order to demonstrate, or at least to raise a reasonable doubt, that someone other than him or herself committed the offense or was more likely to have committed the offense. The starting and leading case on this is a case called Regina and Macmillan, where Justice Martin of the Ontario Court of Appeal ruled that evidence that a third party other than the accused had committed the offense is admissible if, one, it is relevant, and two, there is sufficient probative value to justify its reception. To have sufficient probative value, the third person must be sufficiently connected, that's the test, sufficiently connected by other evidence. To meet the test of being sufficiently connected, the proffered evidence must have a rational connection between the evidence and the third party and not be based on conjecture or speculation. What is a rational connection? Well, the Alberta Court of Appeal in a case called Regina and Latta articulated what is not a rational connection. That was a case in which the accused was charged with the murder of his business partner. He wanted to tender evidence of a witness who had overheard a conversation in a bar between parties who were discussing the deceased, and he heard the following threat: "If I don't get him, someone else will." So the proffered evidence then was an overheard conversation by an unknown person but discussing the deceased. The Alberta Court of Appeal commented that likely this was hearsay, but it was inadmissible on a more fundamental basis, and that was that the evidence raised nothing more than a possibility that this unknown person might have killed the deceased. That is, that it was conjecture, there was speculation, there was nothing to link this unknown person to the offense itself. So that the evidence that someone else may have animus towards the deceased or was antagonistic to the deceased without something more would not be a rational connection between that third person and the offense charged. And the Court of Appeal concluded that it was speculation, conjecture, and an imaginative conclusion, not a rational one. Mr. Latta, not to be deterred, some 3 or 4 years later came up with another witness who would testify again about a conversation that someone else might have committed the homicide. And so a reference was brought by the defense to the Court of Appeal again. This witness was also going to be testifying about a conversation from the deceased that he had said that he was going to be killed, that he had to pay his money, or the boys were going to kill him. Again, the Court of Appeal said, same problem, it's hearsay, we already decided that in Latta number 1. And again, this evidence was so tenuous as to have no probative value, so that threats or a demonstration of animus alone, unless connected by other evidence, is not sufficient. The other principles are that the evidence must be, that is being proffered, must be admissible evidence. As the Court of Appeal said in Latta, it cannot be hearsay unless it comes within an exception to the hearsay rule. And Ontario Court of Appeal in a case called Regina and Williams had also concluded that Williams was a case of arson and manslaughter. Two witnesses were prepared to testify that that someone else had told them that they had in fact set the fire. So it's classic hearsay. And the Court of Appeal said, no, you can call that person, it's hearsay. The defense also tried to proffer evidence of disposition of this third person to set fires. He had on other occasions set fires. And again, the Court of Appeal said disposition alone is not sufficient. You have to show some connection between the third party's disposition and the offense charged. One of the exceptions to hearsay evidence is the declaration against penal interest. If you can come within that exception, then it may be that you will have, or it is, the fact that a declaration against penal interest where the declarant is dead may be admissible. However, for the to meet the test of a declaration against penal interest, there has to be an immediate prejudice. And if there is a lack of that immediate prejudice to the declarant, then the evidence will not be admitted. And the case that dealt with that is a case called Regina and O'Brien from the Supreme Court of Canada. O'Brien was a case in which O'Brien and another man called Jensen were jointly charged. Both of them fled the country. Jensen fled the country. O'Brien was convicted, sentenced, and then sought to bring fresh evidence before the Court of Appeal. Jensen had returned and was prepared to testify that it was he alone who had committed the offense, which was trafficking in narcotics. But Jensen would not give an affidavit to that effect. He had retained counsel. He had made it very clear that he would only testify if he was given the protection of the Canada Evidence Act. Jensen died before he got to testify, and so Jensen, the lawyer, O'Brien's lawyer, whom Jensen had spoken to, sought to give the evidence that Jensen would have given as an exception to the hearsay rule. The British Columbia Court of Appeal allowed him to do that, was satisfied, and in fact entered an acquittal. And it went to the Supreme Court of Canada, and they said no. The evidence of the lawyer of what Jensen had told him was not evidence that Jensen had given under the prospect of immediate prejudice. In fact, quite to the contrary, that Jensen had done all he could to make sure that there was no penal consequence to him, and accordingly the evidence was not admitted and the conviction was restored. The test for admission of defense evidence is also an issue that you have to consider, and whether or not the evidence is going to be admitted, of course, depends on its relevance, but is relevance alone sufficient? And the Court of Appeal of Ontario in two cases, a case called Scopoliti and subsequently upheld in a case called Regina and Yake, have said that relevance alone, even for defense evidence, is not sufficient. There must be something more. It must, they do a cost-benefit analysis and say it must have sufficient probative value to outweigh the costs in terms of the distractions to the central issues and be helpful to the trier of fact in the inference drawing process. The Court of Appeal in Yake had been asked to review that test, that sufficient probative value, and to reduce it to any relevant evidence, and had cited Seaboyer, where Madam Justice McLaughlin had pointed out that courts are reluctant to exclude defense evidence founded on the basis that no innocent person must be convicted. And so the Court of Appeal in Yake was asked in that context and post Seaboyer to review the rule, and upheld the original test and said it has to be something more than relevant. It has to have sufficient probative value, that it's helpful to the trier of fact. The kind of evidence that is proffered or is tendered, it can be anything, of course, but most of the cases that we see and that are in the paper deal with disposition evidence. Obviously, if it's other, direct evidence, it isn't going to be that problematic. But if it's disposition evidence, then do special rules apply? The long and the short of it is that disposition evidence of another suspect is admissible, and disposition evidence of a co-accused is admissible. There are consequences, however, to raising disposition evidence, and that is if the disposition of the other suspect is the same as your client, as the accused, then impliedly, and the argument is that this person, this third party, is more likely than your client to have committed the offense because of this disposition. If your client has the same disposition, then his disposition is in issue. The Crown can cross-examine on that and can call reply evidence, which has obvious trial tactical considerations that ensue. With respect to, in particular, to disposition evidence of co-accused, it's important to remember that if you're raising your co-accused disposition, quite likely he's going to respond in kind, and speaking as a Crown, it's always something that you like to see. Arising out of that is that great care must be taken in the instructions to the jury as to the use that the jury can make of that evidence. And in the case of Regina and Suzak, which is set out in the paper, Justice Doherty makes it very clear that just because a co-accused is raising the disposition or an accused is raising the disposition of his co-accused, does not entitle the Crown to have the benefit of that evidence. And so while the instruction to the jury is that the accused is entitled to say to the jury, you can look at that disposition to decide whether or not he is more likely than I am to be the perpetrator, the Crown cannot use that evidence against the accused. So the co-accused can use it, but the Crown cannot use it as positive evidence of guilt. And the instruction to the jury has to make that very clear. As Doherty J. says, the instruction must minimize the prejudice to the co-accused. And I'll just point out that Justice Doherty does a very good job of setting out what the jury instructions should be, and he adopts the practice jury instructions that Justice Watt and David Butt have drafted in that regard, and I commend them to you. I think that's my 10 minutes.
Thank you. Eddie?
The two aspects are other suspects and the cutthroat defense. Cutthroat defense is used to define when two co-accused turn on each other or one co-accused turns on the other. They call it the cutthroat defense because if you turn on your co-accused, then you're cutting his throat, then you're cutting your throat, and then the trial is over. If it's both cutting each other's throat, then they don't have to cut their own throat because each one's doing it to the other. I can't imagine a case where a Crown wouldn't be thrilled and delighted to sit back and watch two co-accused blame each other. Birds of a feather flock together, but even worse, I don't mind looking over my shoulder at a Crown attorney coming at me, but I don't like to see a defense counsel coming at me because it's over. I don't like cutthroat defenses at all. I think they don't work. I think they are doomed to fail, and any Crown attorney's got to welcome it. What I don't understand, though, is on the other suspect case, why Crown attorneys will fight so hard to keep out this evidence. Normally in a murder case, you've got 8, 10, 12 police officers, 4 forensic experts, 82 witnesses, all saying your client did it. Your client has you pointing at somebody else, and that's it. It's pretty tough to try to prove that it's somebody else that did a crime. And I would think that if the stronger the case for the prosecution, the more likely that you're going to blame somebody else. But if you can win on reasonable doubt, I wouldn't head for that defense so fast, because if you try to prove that somebody else did it, they may just prove that he didn't. By calling that person to say, I didn't do it, I was in Miami at the time, and call a witness and smash, I mean, you're getting very focused, and you're playing a very dangerous game when you want to blame somebody else. Saying actually somebody else, if you want to say, I didn't do it, it wasn't my guy, that's fine. That's a great defense. And that wins. That case wins. Where it runs into trouble is when you point to a particular person. And then when you look at the rules, that they set up, trying to make it more difficult for you to even try to suggest that somebody else did it, it's fascinating to watch. If a little 4-year-old kid says, Jackie touched my wee-wee to his mother, and then his mother says that to a neighbor, and then the mother dies. And then the neighbor says that to somebody in California, and then the neighbor goes to Florida and won't come back to Canada. And the person from California comes up, the court will say, that evidence is admissible, it's trustworthy, it's reliable, and we're going to let that in, and that's what we're going to do, because it's trustworthy and reliable. And so Latta comes along on the reference, and he's got a guy who says, I spoke to Latta. Latta says, I'm going to get killed by the mob because I didn't pay my gambling debts in Vegas. I think that's pretty good, but I'm wrong. Because in Alberta, they said, that's hearsay. It's classical hearsay. I thought there was no such thing as classical hearsay anymore. That if anybody says anything to anybody, dies, leaves, whatever, and leaves somebody who's totally untrustworthy, as long as it's evidence against the accused, it's admissible. Okay? Now, I dismiss Latta this way. Latta was a case of the Alberta Court of Appeal trying to convict an Ontario law professor from Queens, and I think that's what it is. It's a case of the West versus the East. And they don't believe, they don't trust Easterners, so the case in Ontario is utterly irrelevant to me. What is relevant to me is Williams, and I have a problem with this. I mean, you've got two people prepared to come forward saying, somebody said they committed the, was it an arson or whatever? Yeah, it was an arson in Williams. And that's not reliable. And in one case called Carmichael, it was the accused who said, the neighbor told me that she committed the arson. And they say, well, you're an accused. You're not reliable. I mean, you have every reason to lie. Okay? And then they come up with O'Brien. And they say, well, the declaration against penal interest. It's like every time you try to do something, there's a roadblock. There's a roadblock. So the best other suspect defense is circumstantial evidence. The best suspect defense is when you don't try to push the lip into some confession out of the neighbor or out of somebody else. Keep it at the circumstantial evidence level if you can, and avoid having a judge rule it inadmissible. In any event, I like blaming the world, okay, without getting too specific, because if you get too specific, you might just lose.
Thank you, Eddie. On Eddie's last point about how the defense can build up a circumstantial case that somebody else did it without pushing the envelope too far, let me invite your attention to Jeff Schrader's paper. It's How to Prepare for Another Suspect's Defense, How to Build a Credible Theory, How to Think Through the Case with Timelines that will show the weak spots in the Crown's case, show the existence of other credible suspects, how to get disclosure, how to analyze the police investigation, how to attack the police investigation for moving too fast on your client before better suspects were eliminated, how to attack the police investigation on the basis of tunnel vision, and how to assess the downside risk for your client in terms of your client's background or in terms of the defenses the third-party suspects may have if you raise that issue. And I can tell you that it's a good paper, and I can assure you from recent first-hand experience the techniques that Jeff describes can be very effective in court. There are a number of practical issues, quite apart from the doctrines and when all these things are available. How do you raise it? Do you need a ruling from the trial judge before you do third-party suspect? And can you start with your cross-examination of the first police officer with a suggestion about third-party suspects or one particular one? If you need a ruling, when do you ask for it? How do you make your argument? Do you tell the judge what the evidence is going to be? Do you produce witness statements? Do you ask for a voir dire? Again and again, the issues that Eddie referred to, what are the risks of raising another suspect thing? What bad evidence will it open the door for against your client that would not otherwise be admissible? Are there different considerations in judge-alone and jury trials? When do you tip your hand? Do you raise it at the preliminary? Do you raise it at the pretrial? Do you spring it at trial? Do you let the cat out of the bag in your Stinchcomb applications? Is there any merit in trying to sort it out at the pretrial? Be interested to hear as we go on what Hilary thinks of Eddie's view that it may be that in some cases the Crown might welcome a third-party suspect defense if it's not a very strong one. There's different kinds of third-party suspect defenses, and we'll be coming to that. From the point of view of the trial judge, a third-party suspect's defense raises a whole bunch of potential problems. Hearsay problems, you get into all sorts of hearsay problems at every turn. Questions on the scope of cross-examination of the kind ruled on by Mr. Justice Donnelly and Moran. What collateral issue rules, if you make a suggestion to a police officer about a third-party suspect, are you bound by the answer? Can you lead evidence to contradict it? You get into enormous hearsay problems of the kind mentioned. What is the potential to distract the focus of the trial from the real issues? Is there, for instance, a balance now and then of unfair prejudice and probative value? If the defense says there's a lot of fire setters in the building and fire setter Charlie and Brown probably set the fire, does that open the door to your client's teenage record as an arsonist? Can that evidence against your client be excluded on the balance of unfair prejudice and probative value? As soon as you raise this issue, it opens up a number of legal and evidentiary problems. The judge is going to be very well aware of these minefields. And I think most judges go into the trial thinking very much of what's said in the third edition of McCormack on evidence, that the primary job of a trial judge is to keep the sideshow from taking over the circus. So this is going to be at the back of every judge's mind. What's it going to open up? How serious is the issue from the point of view of making full answer in defense? Is it focused? Is it organized? Or is it just a fishing trip and an exercise that will distract the attention of the trier of fact from the real issues? During at some point in the Kaufman report on the conviction of G. Paul Moran, there's a passing reference to the future of the third-party suspect rule, and there's a very brief suggestion that it should be relaxed, that it should be easier for the defense to raise the third-party suspect rule. And as we go through the scenarios, I'll be asking each of Eddie and Hilary to give some thought to those. The first scenario is at page 6 of Hilary's paper. It's the Russian mafia case. Got a fellow called Makhno. He's a Russian mafia, lives on welfare. September, $40,000 pops up in his bank account. Spends $30,000 on a car on September 11th. Evidence of an early morning struggle on September the 12th. The Crown's position is that Makhno was killed during that struggle, something thumping down the stairs. And how's that? It's at tab 2, page 6. And his murdered and dumped body is found miles away a number of days later. His car was gone. The next day, Shavinsky leaves the dead man's car. The Crown says he's dead then with a friend. Shortly after that, Yashnev goes... Sorry, tab 1. Tab 1, page I-6. And then Yashnev makes arrangements to export the car. The car dealer thought the man with Yashnev was the deceased. The Yashnev and Shavinsky flee the country after being questioned by the police. They're brought back charged. They've got a cutthroat defense. Each says that the other did it. Each of them want to introduce the evidence of a Russian businessman called Chapov, who says there's a guy in Florida called Klebner, and that Chapov gave Klebner $500,000 to launder. Klebner, at the end of September, told Chapov that Makhno had been murdered, that Klebner had given the money to Makhno, and he thought that somebody had killed Makhno to get the money. Both accused want to introduce that evidence to show that Klebner used Makhnov's death to conceal his own theft of the money and to show motive and consciousness of guilt by Klebner in Makhno's murder. Eddie, how would you approach this?
I wouldn't take the case. This case actually went to the Court of Appeal trying to figure out what the hell either one of these accused was doing, trying to bring Klebner into it, as the court points out in the appeal court. There's no evidence that Klebner was ever in Canada. There's no evidence of any opportunity for him to commit a crime. There's no evidence of animus between Klebner and Makhno. And you cannot for a moment even view Klebner as a suspect. And when I look and you think about what's the Crown do when they have that? I mean, I don't think they raise, I don't necessarily like the language that the cases talk about in terms of sufficient probative. Relevancy is not enough. It has to have sufficient probative value. What the hell does that mean? I mean, I have no idea. If it's relevant, it's relevant. I don't know what sufficient probative value is. Like, it's got to be really sure or more sure. I don't know what these words mean, but this case doesn't come anywhere close. There's no ballpark. It's just throwing some guy out and that's really the quote that Justice Campbell talked about, the sideshow from taking over the circus. I mean, I know a lot of judges think that a plea of not guilty is a sideshow. That's taking over the circus, but there are cases where the sideshow is something you shouldn't embark upon, and this is such a case. And this is a case where if I were a Crown attorney and I heard this in a courtroom, I'd let it in. I'd let it in. They're going to hang themselves even that much faster. This is a noose around their neck because this has nothing to do with it.
Hilary.
It was clear that there was nothing other than a motive attributed to Klebner. He lived a long way away. There was no evidence connecting him at all. And the bottom line, the Court of Appeal said motive alone is not enough. You've got to have something else. And went on then to point out that just how little there was to connect Klebner, except the fact that his money had gone missing, and ruled that the trial judge had been right in excluding it. And I think the Court of Appeal goes on to say something else that's of value, and that is that it's the trial judge who is in the best position to assess whether or not the evidence has some probative value, because he hears all of the evidence as the trial unfolds, and that in this particular case, the trial judge was aware of all of the nuances of the evidence, and that he couldn't even view Klebner as a suspect, and excluded it.
Okay. My question as a trial judge is that's the way it worked out in that case, but winning. Somebody says, I want to start to cross-examine that policeman on third-party suspects. And there's an issue as to whether or not you require a ruling. I think that if the Crown doesn't want it in, the Crown will say, no, we'd better have a ruling on this, and this should be raised before the jury's sworn. And if you get into that situation, how do you handle it? Because even though the Court of Appeal in that case said, well, the trial judge over the whole trial develops a sense, the trial judge has to bite the bullet very often at the very beginning. Do you start with the first cross-examination of the police officer with the third-party suspect? So as Crown and defense, how do you, if you're required to bite the bullet at the beginning, how do you try to get a body of material before the judge to help the judge rule one way or the other? Do you do it by statements of counsel, by arguments? Do you have a voir dire where you call evidence? Do you do statements? How would you do that, Eddie, if it's a case where you do want it in?
Well, first of all, I recognize that if you're going to blame somebody else as opposed to the world, you're going to actually get down to it and blame somebody else. That if you're going to throw, one of the cases says if you choose to throw sticks, if you're going to suggest that somebody has the disposition to do a certain crime and therefore nobody wants to leave the jury with the erroneous impression that your client also doesn't have that disposition, so that the Crown may leave that. You want to have a voir dire. You want to have a voir dire to find out if you go down that road, what you're going to be met with. In other words, you want a ruling from the judge. If I suggest disposition evidence, am I in trouble? Are they going to be able to lead my client's prior criminal record? Is it going to get, isn't a similar act? And if it is only on the basis of getting in my bad conduct on the basis of a similar act, then is it a similar act? I want to know all this before I go down that road, because I'm going to end up getting killed if I call my client and I don't know what's going to come out. But leaving apart disposition and leaving apart this question of the actual statement that, that you're trying to get in, if it's a circumstantial evidence case where you're trying to establish circumstantial evidence, I wouldn't ask a trial judge for a voir dire. I wouldn't alert the Crown that I'm going to be doing this. I don't think I have to. I don't think I need a ruling. I disagree with the paper that it says that just to do this. A couple of judges have done it, and that's not a trend. This is my defense. I can do what I want. If I want to, my defense, I pleaded not guilty. It means I didn't do it. If I didn't do it, that means somebody else did, unless we're suggesting that it's not a crime what happened, or that there was no offense occurred. Which is oftentimes the case, where you're suggesting that the complainant or the Crown witnesses are lying, that no crime occurred. But in a case where crime occurred, and unfortunately I've been involved in too many of those where an actual crime has occurred and they've just been wrong, okay, in charging my client. But if that's what you're going to do, it means somebody else did it. What the hell do I need a ruling from a judge? And as Justice Campbell has pointed out, what are you going to do? Have a voir dire of the trial so that the judge can hear everything that's going to come out, half of which you can only hope and pray will come out the way you want to. You don't know measure how this is going to come out. And I think you shouldn't ask for a voir dire, seek a voir dire. And if the Crown asks for it, I think you should avoid as much as you can from getting yourself in that position. I tell the judge, you want to voir dire the whole trial? Let's do it. Okay? Short of that, just let me do what I got to do.
Hilary?
I can see why Eddie would not want a voir dire, because this is a real advantage to the Crown to have the defense unfold their theory of the defense, and perhaps even have to unfold the evidence in support of that theory as well. And it's one of the reasons why I think Crowns do like to see other suspect and defenses, because you get disclosure. I think the trend is that you are going to have a ruling from the trial judge. All of the cases that are referred to, in fact, did have a voir dire. That's why there's a ruling, and that's why I suppose I think there's a trend. But the important thing, I think, for the Crown is to be vigilant, because, and I think for the trial judge as well, because while I can see why the defense may want to have all sorts of extraneous evidence in to distract the jury from the central issue, and that is whether the accused is guilty, there are some fundamental principles that say that the evidence has to be relevant, and I think you have to demonstrate that relevance. And depending on the evidence that you're trying to elicit, the only case I think where you might be successful in not having a voir dire, although I'd say the two cases in support of this did have a voir dire, and that is where you are trying to elicit the other suspect evidence from, say, an investigating officer, because you want to demonstrate that the police investigation is biased, that they had always centered on your client in the face of other tips or evidence that pointed to other people, and so you may want to frame it not so much as evidence that is linking somebody else to the offense, but that the whole investigation is tainted, and therefore this may raise a reasonable doubt. That happened in Morin, and Justice Donnelly did exclude that line of investigation from the officer, did not allow the cross-examination, although I have to say in Morin, I think partly it was because it was such a broad, it was not, there wasn't a particular other suspect in mind, it was just somebody else did it, somebody out there other than my client. And Justice Donnelly said, you know, in the abstract, this is just speculation, it doesn't meet the test. The other case, and so he excluded the cross-examination. The other case in which it was permitted is a case called Mallory from Ottawa. And in Mallory, Justice McWilliam did allow the cross-examination of the police officer with respect to the officer's state of mind. And I think this is one of the things that you should be mindful of when you embark on this line of investigation. You just should be careful what you ask for, because you just might get it. And Justice McWilliam did allow the cross-examination. And what followed was there was hearsay from the officer about going to her state of mind. And then there's a whole lot of other hearsay pointing to the accused. And once having opened the door about what other suspect evidence you had, the officer testified how it was excluded and how it just didn't pan out, and kept reinforcing the Crown's case. And I think the sense was it was rather a disastrous foray. So you have to be careful.
Thanks, Hilary. Second scenario, tab 1, page 1-8. Dead baby, mother and father both charged with murder. Baby got the fatal injuries when the only two people who had access to the baby were the mother and father. They're both charged. They both deny that they hurt or killed the baby. It's a cutthroat defense. Each of them points a finger at the other. Husband wants to call evidence that the wife never wanted the baby. She was a psychopath, quick to anger. Crown says that if the husband calls that evidence, the Crown should be able to cross-examine the psychiatrist to show the husband also is a psychopath of the same kind. Two questions. Can the husband lead evidence of the wife's disposition? Can the Crown cross-examine or call reply evidence about the husband's disposition? Then a further question, do you treat the disposition of a co-accused differently from the disposition of another suspect who is not a co-accused? Eddie?
Well, I mean, that was all resolved in the McMillan case, and the underlying principle is this. Yes, you can lead evidence that someone else had motive, opportunity, disposition to commit the crime. And the door you open is the door that I think Justice Martin explains so well in McMillan and following in Scopoliti, that if you're going to try to lead evidence of disposition or evidence of aggressiveness in Scopoliti on the part of the deceased as a matter of circumstantial evidence so that the jury can draw an inference as to who was the aggressor and whether this was self-defense or not, the door you open is you've got to have a pretty squeaky clean client. You've got to have a client who does not have that disposition because the door is open. The Crown can lead that contrary evidence. And so in McMillan, the answer is that was given is very clear that that if you're going to lead that evidence, and you can, then you open the door to the evidence being led against you. The tendency or disposition of a person to do a certain act is relevant to indicate the probability of his doing or not doing the act. And so it all goes in. And that's the risk you run. And yet in McMillan, that may be the best way of dealing with it, that if it's one or the other and the jury can't pick, that may be the one kind of cutthroat defense that's possible, where you can win, when they're left with not knowing, although I think the tendency would be to convict everybody and not worry about 21-1, 21-2, 22, 23. I don't think so. I think that the tendency is to say a pox on everybody's house.
Hilary?
I agree, and the problem with for Mr. McMillan was that the psychiatrist who had examined the wife was not a co-accused, so the psychiatrist who had examined the accused, the wife, had also examined the accused, and it was just a bonanza for the Crown. I don't know how often that would happen again, and of course that allowed the Crown to cross-examine, or the Court of Appeal ruled the Crown should have been allowed to cross-examine the psychiatrist, because his evidence was that not only was the wife a psychopath, so was the husband, and didn't advance his other, more likely disposition argument very far. I think also what the Court of Appeal in Macmillan pointed out was that not only can the Crown cross-examine, but can also call reply evidence, so that if you're in a position to have other psychiatric evidence with respect to the accused after the accused's case is in, you get to call this evidence, which is obviously very damaging. It's the last evidence that the trier of fact is going to hear. And if it wasn't bad enough just cross-examining the psychiatrist, having another psychiatrist come in reply must be very, very poor timing for the accused and pretty damaging. And I think it's worth pointing out that there has been a recent decision of Madam Justice Sharon from the Court of Appeal in Rogers, which reaffirms the right of the Crown to call reply evidence, and it's a little bit different in the sense that in Rogers the accused had been convicted, wanted to tender fresh evidence on appeal that somebody else who had committed other offences with a similar MO had committed the offence, had not raised this at trial. I guess the evidence wasn't admissible. On the application to the Court of Appeal to admit that evidence, the Crown brought an application or a cross-application to say, well, we know that Mr. Rogers has been seeing a psychiatrist. We want an order to examine that psychiatrist, for him to attend, bring all his notes, all his progress notes, his reports, and then that evidence also has to be tendered at the fresh evidence hearing. And the Court of Appeal agreed, said yes, ordered the psychiatrist to attend. So not only, the Crown isn't always going to be in a position to know whether there has been a psychiatrist seeing the accused. After the fact, obviously, in Rogers they did and were successful in bringing the application. And Justice Sharon talks about the importance of the trier of fact not having being misled as to the disposition of the accused. Talks about a case called Parsons, and Justice Dixon talked about it in Corbett as well. You can't exclude that evidence if you are going to raise disposition and you have that disposition as well, or something similar. It is misleading to the trier of fact, and all of the evidence goes in. So it's something to bear in mind, again, when you're deciding to raise that disposition evidence.
Thanks. Fact scenario 3, it should be in the last page, double-sided page in tab 1. Case of the Lookalike rapist. The accused is charged with rape and abduction of a teenage girl who was held at gunpoint after a field party or bush party, and then driven by the assailant in a car to a hunting shack where she was raped. The accused matches, there's a detailed description of the assailant's car. The accused matches a physical description of the assailant and has a car that's very similar but has one material difference from the car of the assailant. He's familiar with the hunting shack. and had some knowledge of the field party. Your client says he's not the guy. Your client has what Eddie Greenspan would call a fantastic alibi. He was at home watching television by himself on the night in question. He says his old buddy, Eddie wrote in his paper, Great Defense. He says his old hunting buddy fits the description of the assailant. He's got a car that matches the assailant's car in almost every respect except one material respect. He's got access to the hunting shack. There's a number of different questions and scenarios. Instead of repeating them and then repeating them again, because we're getting towards the end of our time, Eddie, could you take us quickly through those things on the last page of the material?
What do you do with the information? I think that's pretty good information to blame somebody else. And so I'd probably hold that back until the trial, and I would bring it out through the first officer who testified and get it right out on the table. If I were to have exactly what's here, that the client says I didn't do it and says that he's home drinking and watching Saturday Night Live all by himself, and I've got nothing more. Okay? I've got nothing more than him saying that. I think that I would blame somebody else. I'm not sure that's a seriously strong defense. Unless he presented well and got rid of his ponytail and cleaned his act up, I think I'd want to blame somebody else, and so I'd blame him at the trial. Let the Crown call this guy in reply to say he didn't do it, so I can cross-examine the guy to suggest he did and hope I can raise an inference that he's a more likely rapist than my guy. Second question is do I give information to the police and request that they conduct an investigation? I've never met a policeman who was prepared to concede that he was wrong about who he arrested and charged. Even when DNA is in the Moran case, the cops still believe that they got the right guy. And so handing them information to go check out another suspect is handing them information that they can smash and make sure you can't raise it. They're not going to go and say, thank you very much, and go out and come back and say, you know what, we made a mistake. If anybody's had that happen, I've never had it happen. I've never heard it happen. So I wouldn't let them know anything, and I wouldn't bring them in on anything, because they will ultimately get the evidence that will hurt you. Assume that you've provided the information to the police, and they've advised you that their investigation is completed because they've arrested your client, surprise, surprise, and they're not interested in information. What do I do about the police lack of interest in the alternate suspect? Nothing. They're not interested. They're not interested, and what are you going to do? You're going to try to raise a point at trial and say, why didn't you do this? Because your client's guilty. Why didn't you do this? Because your client's guilty. You can't win. You can't win on that, and so you've got to make the injustice come from other angles, like evidence you raise, private investigator you retain. You try to call that witness at the trial. You learn rumors that the alternate suspect has been investigated for sexual assault in the past. Can you obtain disclosure? Well, I think you can obtain disclosure, but the question is, do you want to obtain disclosure when you haven't told them that this is what you're going to raise? I'd raise it, then ask for the disclosure in court, so that I would have it on the table before I asked for the record of that person. The next question, after many hours of drinking, the alternate suspect made the following comments to John, the neighbor. A buddy of mine just got arrested for some rape in a hunting shack. I feel bad, but sometimes someone has to be the fall guy. I would hope the trial wasn't in Alberta, but if it's in Ontario, it's got to go in. I mean, even my friend Hilary would have to concede that that would be admissible, more than tenuous, highly probative, highly relevant, and the guy's confessing to committing the crime and is doing it in circumstances where it is a declaration against penal interest. It's immediate. It's not protected. It goes in. I don't think there can be any dispute about that. We don't even need a voir dire. The Crown will not call the friend to testify. Do you call the friend to testify? You got to be pretty dumb to call somebody to say, I'd like to accuse you of a crime. Did you do it? In chief. I mean, you're calling them in chief, and you're never going to get a declaration of adversity from a trial judge on that, so don't try. But what you've got to do, and this is actually quite interesting, you've got to, if you're focusing in on somebody, you start with witness one and you focus in and you focus in, because the whole point of this focus is to make them call that witness. You've got to get the Crown into a position where they call that witness. And I mean, it's a huge risk. It's a huge risk. But you got to hope that that witness has bad demeanor and bad vibes and may be that rapist, so that you can get up and make all the suggestions you want to him. And then those suggestions, even denied, will give you a basis of making a jury think twice. They got to see this guy, not with you calling him. That's, I don't think, smart.
Thank you. Bev and Todd, we got going about 10 minutes late. Can we have about 5-6 minutes to wrap it up? All right. Hilary, briefly on that.
No, Eddie, it's not admissible.
I accept that.
We do want a voir dire. This is one of those cases where I think you just can't get around having to demonstrate relevance and having a voir dire. I think the statement is a classic Williams. Williams was exactly the same. Regina and Williams, where the accused is supposed to have said to somebody else, just like John the Buddy, made a confession. Court of Appeal said in Williams, you can call the person, it's hearsay, it's not going in. In fact, in Williams, they did call a person, the defense did call the person in chief, and it wasn't very successful. But it's not going to go in as a hearsay confession. Same problem with as in Lata, and the fact that it is a confession doesn't make it any more admissible. The problem, of course, as well as Eddie had referred to earlier, is that the court tends to feel that there's a self-interest in an accused, where the only evidence is coming from an accused. In this particular case, the buddy has made the statement to someone else, but that doesn't make it any more admissible. With respect to when you would tender this, first, whether at trial, at preliminary hearing, as pointed out, if you ask for this information, although I think it would be a good idea to get this in advance, because as you'll see in the fact situation here, in fact, John has, or the buddy has an alibi, a pretty good alibi. And if this is tendered, the police go out and speak to him. They discover that he has a good alibi. The Crown might just call him and put in his alibi as well. So it's fraught with difficulties if you don't investigate it early enough and know just what you're dealing with. I agree with Eddie, though, that these are defenses that really are fraught with problems, and my view is it's better to know them up front than to be left holding them at the trial.
Thanks, Hilary. Eddie, in 1 minute, can you wrap up?
I'll wrap up very quickly this way. I remember reading many, many years ago in Glanville Williams' little Hamlin lecture, The Proof of Guilt, that where you relax the rules of evidence is where an accused is trying to establish his or her innocence. That's where you relax it, because what you want to avoid is an injustice. What you want to avoid is the possibility of the wrong person being convicted. And that rule's always stuck with me. It's sort of flirted with in Seaboyer, but that rule is such an important rule. If an accused comes forward and says, well, somebody said to me, you son of a bitch, I did it, and you'll never be able to prove it. And the accused wants to get up and say that was said. Well, he's unreliable. He's unreliable. He's not trustworthy. He's not credible. He's unreliable. Well, what if the accused happens to be a priest who's never been in trouble before? Never been in trouble before, and has been reliable, is credible and trustworthy. I think we've got to get underneath these rules. I think that Williams is so horribly decided, And I think that we can't live with that. You've got to try to impress at a trial level every time you're there on a judge that what may be happening is an injustice. And if you can convince a judge of that, they'll all of a sudden move to, you know what, this is probative. But you've got to be able to do that by force not only of advocacy but of evidence. You've got to be able to try to build this case in a way that will attract a trial judge. And then, I don't think these rules matter much, because even when you go to that case in the Supreme Court of Canada, Justice Major and Arcangeli, it was the accused who said that the other guy did it. Now, there was a little evidence that the other guy had stabbed somebody a little earlier that day, and thank God for that evidence, but it did emanate from the accused. And it requires you to be able to build that case and circumvent the presumption that your client is going to falsely suggest that somebody else did it. The presumption that the police obviously have the right man, which is a proposition of law that my mother firmly believed in, and most judges believe in, and that's why they fight this rule, unless, of course, the irony, unless it's a rule being used against the accused, then they'll relax it all to hell and let it in. And this is what you've got to do. You've got to create some cogency in the suggestion, and you don't need a lot of evidence. I've suggested other people did it without really the basis to do it. Whole line of cases, Ben Cardino and DiCarlo. Crown attorney wants to make a suggestion to a witness, to make an imputation against the witness. Court of Appeal in Ontario says, that's okay. We don't like the idea that you might want to blame David Humphrey, counsel, when you want to suggest that one of his clients caused this witness to switch, Ben Cardino and DiCarlo, but there's a whole line of cases that say a Crown can ask questions when they've got no basis to put it. Well, what's the matter with us? And you don't see the Ben Cardino and DiCarlo rule being discussed in this whole area as to what the rights of questioning are. And I think that's an area that we can develop as defense counsel to go through that whole line of cases and say, look, if a Crown can do it with witnesses, why can't we do it with witnesses?
Hilary?
Well, I think it just goes back to fundamental principles. It's easy to raise all sorts of conjecture and speculation. It may be nice to be able to admit evidence that's speculative, just on the off chance that it might go to show the accused innocence. I think Justice McLaughlin was very open to that in Seaboyer, but she still talked about that the evidence must have a legitimate purpose and that it must logically support the defense. And that's why we have rules of evidence with respect to relevance and probative value, that we can't embark on every wild pursuit just because it looks good. And we still have those general principles. I think the Court of Appeal had the opportunity in Shavinsky if they wanted to relax the rules, and they didn't.
Thank you both.